Discrimination on the basis of pregnancy and pregnancy-related conditions is an ongoing challenge women face at work. In April, a new law went into effect barring that. It also put other protections into place. I discussed that as well as how we got here, the effect that these behaviors have, and more with Dr. Carrie Baker, Smith College's Program Director for the Study of Women and Gender.
In 2015, the Supreme Court ruled in a case called Peggy Young versus UPS, United Parcel Service, and that case really raised a lot of awareness about the kinds of conditions that women experience in the workplace when they're pregnant. Peggy went around the country and talked about her experience. In addition,
she's a UPS driver, right, who was pregnant and said, I can't lift X amount. Usually you have to be able to lift, I think it's 50 pounds. And she said, for the short term, I can't lift that much weight. And then they laid her off. Yeah,
and so she requested accommodations, temporary accommodations while she was pregnant. And UPS actually provided those accommodations to some workers, like workers who had been injured on the job,
or workers, or something like that.
Right, or workers that were covered by the Americans with Disabilities Act, but pregnant workers were not covered. This case arose under the Pregnancy Discrimination Act, which is a federal law.
Right, so federal law, but here in Massachusetts, this law just went into effect, this act just went into effect. So now where do we sit compared to other states?
Well, so first I just want to say that Ellen Story, who's a local representative, is the one that drafted the legislation in Massachusetts with a group, also a local group, called Mother Woman in Hadley. And of course, Ellen was no longer in the legislature by the time they voted on it, but that was back in 2015. And so finally it passed, and it passed unanimously in the legislature. So there was a lot of support for this kind of law.
But Massachusetts is still in the minority, right, of states that have this type of protection on the books.
So about 19 states have some form of reasonable accommodation law that requires employers to accommodate pregnant people within reason. And so, yeah, we're still in part of the minority. And we have a stronger law now than many other states that even do this.
Let's look at the nuts and bolts of the act.
Sure.
When you say within reason, we're talking about accommodations for women who have just had a baby. What are the accommodations that need to be made for them now?
So the act does two things. It prohibits discrimination based on pregnancy or pregnancy-related conditions, and it requires that employers provide what's called reasonable accommodation. And what that means is that it requires the employer to sit down with the employee who is pregnant and engage in an interactive process in good faith where they develop a modification or an accommodation or an adjustment to the working conditions that would allow the employee to do the job, do the essential functions of the job without undue hardship on the employer. So it's things like providing seating, providing breaks, providing a private non-bathroom place to express breast milk. So, there are different kinds of, providing that they don't have to lift over a certain amount. And depending on whether they're not required to have medical documentation for certain things like seating and breaks, but if it's more than that, then they need medical documentation.
But we're in 2018.
Yeah.
How is it that we got to this point where this wasn't provided previously? I mean, there are the women in the workforce make up 74 million people.
Yeah, and 3/4 of women three-quarters of women will be employed and pregnant at the same time. And so it impacts a tremendous number of women. This has been an issue for a long time, and feminists have been pushing for this, but it really wasn't until the UPS case that really there was high-profile attention to the case. The Pregnancy Discrimination Act, the federal law, doesn't require accommodations. That was the act at issue in the UPS case. It only requires non-discrimination. And so this is really a more recent demand, and it's kind of parallel to the Americans with Disabilities Act, which does require accommodations for people with disabilities, but that act exempted pregnant people because pregnancy is not a sickness, it's a normal thing. But it really was unfair because women that were pregnant were not able to continue to
Take them
work
into account.
often. Yeah.
So currently there is federal legislation looking at this issue too. What do you think the likelihood is that that will actually go anywhere?
Yeah, so Congress is considering amending the Pregnancy Discrimination Act to require reasonable accommodations, but I think it's highly unlikely that the current Congress is going to do anything, and I don't know if the current president would sign an act like that, primarily because, you know, it does require something of businesses, and I think the current federal legislatures are very pro-business.
I'd like to have us look at some statistics just to show how things have changed in the last 50 or 60 years. So the Census Bureau tells us that more pregnant women work, as I said before, compared to 50 or 60 years ago. In the 1960s, 44% of women worked at all during pregnancy, and 65% usually stopped before giving birth. Right. Compared to 2008, which is, that's the most recent data available, 66% of mothers gave birth while they were, they continued to work, and then 82% worked up until maybe a month before. Right. We're also seeing more claims being put forth by women who say they're facing discrimination in the workforce, 31,000 recently. Are we seeing, do you think, more instances of discrimination, or is it that more women are in the workforce?
I think that women are demanding more. I mean, they need that accommodation. They need those jobs. I think in the past they could maybe afford not to work, to leave the workplace, but now you can't afford to do that. And so I think the conditions have changed. I think there are, like you say, there are more women in the workplace, but I think they're more aware of their rights. I think there's been a lot of work to try to make women aware that they are entitled to be able to work while they're pregnant. So I think all of those factors contribute to this issue.
What about the issue of paid leave? We heard when, I think it was Netflix and Facebook, made some very generous changes to their paid leave policies, but there are many companies who don't offer any paid leave or very little paid leave. So where are we on that issue?
So the United States is one of just a handful of countries in the entire world that does not guarantee paid leave to pregnant people. And it's really quite appalling. The U.S. thinks of itself as ahead of the world on a lot of human rights issues, but we are way behind on this. The Family Medical Leave Act guarantees 12 weeks of unpaid leave for employers that have more than 50 employees, but many people can't afford to take unpaid leave. And then just a handful of states now are starting to require paid leave, like California and New Jersey. Massachusetts is not one of those. I think folks in Massachusetts are going to be pushing for that.
I want to ask you about a book that you wrote. It's called The Women's Movement Against Sexual Harassment. And in that book, you looked at how sort of social change really put pressure on policy to affect change around that particular issue. Do you think that we'll see something similar when you look at rights for parents, either male or female, coming to support a child?
Absolutely, because again, people have to be working to be able to make ends meet. Rent is expensive, food is expensive, and if they're not working, they're not going to be able to feed their new child. And so I think it's just they're getting crushed, and this is a real need. And I think that's why it was unanimous in the Massachusetts legislature that this was a good thing to do. I think people recognized that this is fair. The act is written so that employers, if they're under an undue hardship, they're not required. But if they can do it, make an adjustment to the workplace, make an adjustment to the equipment that's being used without too much cost or too much burden to the employer, that they need to engage in that interactive process to come up with a solution.